All right, good afternoon. It is 4:30, the 28th day of March. I'm glad you are here. None of you can leave, by the way, because we barely have a quorum. Want to keep it that way. So I will send the Sergeant of Arms right here, the most credible Sergeant of Arms we have. He will snag you and drag you back. All right, are there any personal orders while we're here before we take the roll? Chairman Doggett.
Thank you, Mr. Chairman, and I want to apologize to the members of the committee and to those of the general public who usually tune in to our subcommittee meetings at 12 Central Time on Tuesdays. I failed to go to our Sergeant of Arms today for his weekly words of wisdom. And so, Mr. Chairman, if you would, I would ask that you entertain that idea and allow him to share his weekly words of wisdom with us.
I noticed that did not happen. I thought maybe he had no wisdom for this week.
Well,
but yes, let's go right ahead with the Sergeant of Arms and the words of wisdom.
Good afternoon, ladies and gentlemen. Today's words of wisdom are brought to you by the Queen of Rock and Roll, Tina Turner. The future belongs to those who believe in the beauty of their own dreams. Have a great day.
And there you have it. That's a lot better than last week's. All right, any other personal orders from anybody? All right, Madam Clerk, please take the roll.
Representatives Campbell, Carringer, Davis, Doggett,
Present.
Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Vice Chairman Gillespie, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. First up is item number 1 on the calendar, House Bill 0535 by Cochran. You have a motion and a second, sir. You are recognized.
Thank you, Mr. Chairman. I have one minor amendment to add, if you don't mind.
Is it 3205?
Mr. Chairman, that is correct.
Motion? Second. We have a motion and a second on the amendment. Do you want to explain it or attach it?
Sure. I'll just explain it briefly. This is just naming what the act is known. This act is known and may be cited as Dillard's Law.
All right. Question's been called on the amendment. All those in favor of Amendment 3205 say aye. All opposed, no. Ayes have it. The amendment's now on the bill. Please explain the bill.
Thank you, Chairman and Committee. Essentially, what this bill does is currently already law if, let's say, there's an incident with a drunk driver and a parent is killed in that accident. The drunk driver can be liable for child support payments. That's currently as criminal restitution. This bill would allow, if the family chooses, and the family would have to pursue this on their own, they can convert that. They can pursue to convert that to a civil judgment to collect in that way. I will yield to any questions.
All right. Are there any questions for the sponsor? I'm sorry, Chairman Gillespie.
Thank you, Mr. Chairman. Pardon my ignorance here. I was just curious. Would it be the same mechanism for the criminal as it currently is written for the for the civil lawsuits? Is it just if the parent is killed in the DUI crash? So we're not changing any of that. It's just.
Go ahead.
Thank you, Chairman. That's correct, Representative.
Thank you.
Mm-hmm.
Question been called on the bill, House Bill 535. All those in favor say aye. Aye. All opposed, no. Ayes have it. Moves on to count and rule, sir.
Thank you, Chairman and Committee.
Next is item number 2 by Chairman Terry. It's House Bill 982. Chairman, you're recognized. You have a motion and a second. You're recognized, sir.
Thank you. And there is an amendment to 5862.
Let me see if that's what 5862. That's what I have. Yes, sir. There's a motion and a second on the amendment. Do you want to explain the amendment or do you want to attach it?
Whatever you
Well, we
works
could
for
be
you
here
guys.
all day. It's whatever you think. We've got a motion. Is there a second on the motion? There's a second also, I think, by the same person. All right, a motion and a second on Amendment 5862. All those in favor say aye. Aye. All opposed, no. Ayes have it. Your amendment is now on the bill. You're unimpeded, sir.
All right, thank you, Chairman and Committee. And what this amendment in this bill states is that if a patient's statement regarding the use or possession of marijuana to a doctor, pharmacist, nurse practitioner, or PA during the scope of their medical care for the purposes of obtaining medical advice about interactions of marijuana with other medications or their medical treatment. It won't be used against them in a criminal proceeding. And so one of the reasons why I brought that for you today, and some of this may fall under HIPAA, but one of the reasons why I brought this is this past January, the American Society of Regional Anesthesia put out guidelines on asking patients about marijuana use and there being issues with postoperative pain and such. And so just because we can ask them doesn't mean that they're going to tell us, but this would explicitly put that in there where we can say to them, hey, this will help you in your course of anesthesia. So I'm happy to answer any questions.
Any questions for the sponsor? Representative Fritz.
Thank you, Mr. Chairman. I may be behind on some of these questions, Dr. Terry, if you don't mind. First, my first question would be, if we fill out the patient sheet that most of us do when we go for any kind of doctor or medical procedure, and we disclose any use of illegal drugs, does the physician have an obligation to report such?
Go ahead.
I don't believe that we're reporting that to anybody. Now, if their medical records are part of a criminal proceeding or something along those lines, those may be discoverable, I would believe, but no, they don't turn around and tell on somebody.
Yes.
One follow-up, please. So this one specifically talks about marijuana. Would the same thing apply to cocaine or heroin or methamphetamines, or this bill is just dealing with marijuana, I'm assuming, and why?
Yes.
Thank you. And yes, strictly marijuana. And again, the American Society of Regional Anesthesia put out guidelines this year specifically dealing with marijuana. And one of the issues has to do with escalating percentages and amounts that people are taking. It does impact their postoperative pain. Now, in small doses or from a medical standpoint, it may actually help decrease the amount of opioids they're taking. But if they're smoking high doses or something like that, it may impact their pain postoperatively. So for me, being able to ask them about that, I might want to do a regional block, like a nerve block on their arm or something, so that I don't have to give massive doses of fentanyl or something in the recovery room to help those patients. And the reason we have like nurse practitioners or nurses or PAs or something like that on there, in addition to the issues that come through the ER, oftentimes we have anesthesia clinics and we have a nurse or somebody down there that's asking them those questions.
Yes, sir.
One more follow-up. Thank you, sir. Thank you again for the note. It specifically references THC. So I went to marijuana, and the notes actually say metabolism of THC. So would this also include the CBDs and all that have the lower concentrations of THC in them, and how would that be protected for the doctor and the patient in that case? Thank you.
So on this, it's talking about the use of marijuana, and marijuana obviously has multiple chemicals in there. But to your point, if you're talking to a pharmacist and you have certain drugs out there, there are some drugs that if you are prescribed that drug, it might actually prolong the effects of marijuana in your system, and so you may have somebody that has an adverse reaction from that. That's why we have pharmacists on this. Conversely, there are other drugs like theophylline, which it's a drug for asthma, which I used to have to take. It's like it's kind of related to caffeine, but it actually has an interaction with that speeds it up, so that it may not have the effects that you would expect for that patient, and so you may actually excrete that medicine quicker and may not have the effects, and so it's for all the chemicals that are in there.
Any other questions for the sponsor? Yes, Representative Johnson.
Just a really quick one. Thank you, Mr. Chair. I was reading things, but I was passing through quickly. I thought I read an article that said that if you do use cannabis, it can affect like the amount of anesthesia you will need. Was that an accurate thing that I read, or is that a study you've heard about?
Yes.
Thank you, and yes, it can, and that's the issue that we're getting at, particularly for postoperative pain. And that, it goes for opioids as well. Those that take massive doses of opioids can get opioid-induced hyperalgesia, which you just have to give them, treat them differently in the recovery room. And so it's similar along that lines.
Okay, so it's more specific to the pain than it is to while they're under, or getting them under, I guess.
Well, it kind of just depends and what they're, if somebody's, lower doses and if from a medical standpoint, that may not have any impact on them, but if they're taking massive doses of it, it may have more of an impact on them.
Okay. Leader Lambert.
Thank you, Mr. Chairman. And Dr. Terry and Chairman Terry, is it fair to say, the importance of this bill is that a doctor should know anything that someone's taking, and be it anesthesia or anything else, if they're putting substances in their body, you want to make sure the doctor knows that and that it's full disclosure, both directions, so that the doctor can properly care for them. Is that fair enough?
Oh, absolutely. And this bill isn't just to help the patients from their perspective, it's to help the doctors take care of the patients. Yes, absolutely, yes.
Thank you.
Any other question for the sponsor? Question's been called, so the bill protects disclosure of the patient, but if the anesthesiologist replies and says, yeah, I smoke it every day, there's no coverage for you then, right? Just making sure.
You are correct.
All right, we're voting on House Bill 982. All those in favor say aye. Aye. All opposed, no. The ayes have it. It goes on to calendar and rules, sir, and if you'll stay right where you are, let's committee move to item number 14. That is House Bill 514, also by Chairman Terry. You are, there's a motion? A second? You have a motion, a second. You're recognized.
All right, thank you. And this deals with the same topic, and I believe the amendment is following it over from Health. And as you guys are aware, we do have a cannabis commission. And so what this does is for the governor, when he makes his appointments, it's going to be this July. One of those just needs to be a patient.
All right. Any questions for the sponsor? Representative Fritz.
Yes, sir. Thank you, Mr. Chairman. Quick question on this, Dr. Terry. Thank you again. Qualifying conditions to use, is this bill going to outline folks that have qualifying conditions and are being treated with THC or marijuana or cannabis for the illness?
Yeah, great question. When we passed the Cannabis Commission a few years ago, we put in there qualifying conditions. Those are Alzheimer's, ALS, cancer, inflammatory bowel disease, epilepsy, MS, Parkinson's, HIV, or sickle cell.
Yes.
One follow-up for that, since marijuana is a Schedule I drug, can we have folks that are actually being tested with that? Do we have folks in the state currently that are legally using marijuana to treat those qualifying conditions?
Thank you. And with that, we did have some oils that you can use. And then there's this past fall at the federal level, they passed the Medical Marijuana and Cannabidiol Research Expansion Act, if I can get that out, which if someone was in research from that aspect, then they could qualify as well.
All right, any other questions? Leader Lambert.
Sorry, Mr. Chairman, I'm just trying to save mine to the last on each one of these here. We're not talking about patients that are using marijuana. We're talking about patients that have been diagnosed with the conditions
Correct.
that this entity is studying, correct?
You are correct.
I just wanted to make sure. I thought that's what the amendment said. I just wanted to clarify. Thank you, Chairman.
Any other question for the sponsor? Question been called on the bill. We're voting on House Bill 514. All those in favor say aye. Aye. All opposed, no. Ayes have it. Sir, it moves on to government ops.
Thank you, Chairman and Committee.
Thank you, sir. We're back on the regular calendar. Item number 3. House Bill 1251 by Chairman Crawford. There is a motion and a second. Chairman, you are recognized.
Thank you, Mr. Chairman. Thank you, committee. This is a correction that we're making. A lot of you will remember last year we passed a bill dealing with child pornography on cell phones. And this year we've kind of had a couple of judges that have found loopholes in this and started throwing cases out. So we're going to fix that. And basically what this bill does is it goes into TCA 3913-529, and it changes a word from lascivious to sexual activity. And that matches up exactly what we have in the other code, TC 3913-529. I can go into more detail. You probably don't want me to, but it makes them. Come on, dog it. I practiced all week.
The question has been called on the bill. We're not going to wrestle in the public arena this time, so the question has been called on the bill. We're voting on House Bill 1251. All those in favor say aye. All opposed, no. Ayes have it, sir.
Thank you, Mr. Chairman. Thank you, committee, for not making me do that. I appreciate it.
It moves on to calendar and rules. Next is item number 4. Is that correct? It has been rolled 1 week. We're now on item number 5 by Chairman Rudd. This is House Bill 1000. You have a motion? You have a second? Sir, you're recognized.
Thank you. We had Amendment 5120 put on sub.
5120 is what I have. A motion and a second on the amendment. Do you want to attach it or do you want to explain?
Yes, it makes the bill.
All right, we're going to vote on Amendment 5120. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Go ahead.
As you know, I'm chairman of campaigns and elections, and I take our election laws very seriously. I've had numerous bills before my committee over the years that were too broad, and I've always stated in my committee as well as in my campaign material that I believe sometime when someone has committed a nonviolent offense with no monetary value, that eventually they should have a path to get their citizenship rights back. And that's what this bill does. This is, if not the strictest, one of the most strictest expungement bills in state history. If you have been convicted of voter registration fraud or vote fraud, and you have you served your sentence, paid your fines and court costs, and you have not been convicted of a crime for 15 years, you can get your rights back. And I'm trying to set an example that we take our election laws very seriously. That's when it's a felony, and you can get it back, and this is what the example I want to set, that if you meet these standards.
All right, Chairman, thank you. Are there any questions for the sponsor? No questions. All right. We are voting on House Bill 1000. All those in favor say aye. Aye. All opposed, no. Ayes have it. Sir, it moves on to calendar and rules.
Thank you, Chairman. Thank you, committee.
We're now on House Bill number 6, item number 6, House Bill 1016 by Chairman Grills. You got a motion? Got a second? Chairman, you're recognized.
Thank you, Mr. Chairman. Are we on 1016 or 1013? Okay, just making sure. I've got two folders here, and I had the
1016 is what I'm
showing. I got my
showing.
notes mixed up there. Sorry about that. Now I'm confused again.
That's on the enhancement calendar that's coming up. You'll have to wait on that one.
All right. We have an amendment over there, Mr. Chairman.
Is that Amendment 4972?
That's the same one I have.
All right, you got a motion and a second. Do you want to explain the amendment or put it on the bill?
Put it on the bill. It makes
All
the
right, all those in favor of Amendment 4972 say aye. Aye. All opposed, no. Ayes have it. The amendment's on the bill. Go ahead, sir.
Thank you, Mr. Chairman. This bill adds a definition to clarify what school property is in 3913-114. And second, this bill adds student to the communicating a school threat part of the code. Currently, it only has the employee listed as one that can be charged for such threat. That's what I'm doing, sir.
All right. You've heard an explanation. Any questions for the sponsor? Yes, Representative Hardaway.
Thank you, Chairman. Sponsor, is the threat to the school in general, to the employee, or to the student?
Mr. Chairman, thank you. The definition here, school property means any school building, bus, school campus, grounds, recreational area, the athletic field, or property owned or used, operated by any local education agency, private school board of trustees, or directors. And later on in the bill, if you'll go, I believe it talks about to whom the person has made a reasonable, the threat lays on out in section 2, 3, and 4. If you read that there in the bill.
So it's about, what you're adding is who the threat is communicated through.
Who is communicating the threat and who they're threatening.
Okay, gotcha. Thank you.
Pause just 1 second. All right, any other questions for the sponsor? All right, seeing none, we are voting on House Bill 1016. All those in favor say aye. All opposed, no. Ayes have it. Moves on to calendar and rule, sir.
Thank you, Mr. Chairman.
You want to, no, you're going to have to wait till the next calendar, but it won't be long. All right, we are now on item number 7, House Bill 1248 by Chairman Powers. Chairman Powers, I'm sorry. Well, I'm sorry. Got ahead of myself. We're on item number 7, House Bill 1242.
Right.
By Chairman, and you got a motion and a second. You're recognizing, I think you got an amendment, don't you?
Thank you. Yeah, thank you, Mr. Chairman, committee. Yeah, I do have an amendment, 6069.
6069 is what I have as well. Do you want to put the amendment on? Or you want to explain it?
Please.
All right. We got a motion, a second. We are on amendment 6069. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Now you can explain it.
All right. Thank you, Mr. Chairman, committee. This bill is about, House Bill 1242 is about a drug called xylazine, also known as a zombie drug. It's a non-opioid veterinary tranquilizer used in horses and cattle, which has been connected to several drug overdoses in the country, including 8 in Tennessee. Xylazine is a central nervous system depressant that can cause drowsiness and amnesia, slow breathing, heart rate, blood pressure to go dangerously low, and now it's being used to cut fentanyl and meth. In the event of suspected overdose, experts recommend giving the overdose reversal Narcan, but Narcan has no effect at all on this drug. And after taking this drug, the patient will die. I've been working with TBI, the DAs, and the veterinarians, because they use the drug too, to get this correctly scheduled. And if passed, this bill will make xylazine a Schedule III drug. And with that, Mr. Chairman, I renew my motion.
All right, any questions for the sponsor? Question been called on the bill. We're voting on House Bill 1242. All those in favor say aye. All opposed, no. Ayes have it. Moves on to finance, sir.
Thank you, Mr. Chairman.
If you'll stay right where you're at, we'll go to item number 8.
I'd be glad to.
Which is House Bill 1248. Is there a motion? And a second. Sir, you're recognized on 1248.
And we have an amendment on here that makes the bill too.
Is that 3806?
It is.
All right. Do you want to put it on? You want to?
do.
All
Yes.
right. Motion and a second. We're voting on Amendment 3806. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Go ahead.
Thank you, Mr. Chairman. House Bill 1248 is the Elder Financial Abuse Hotline Bill. This bill will create a hotline with TBI that financial institutions may utilize when there are instances of suspected elder financial exploitation. We have over $500 million of elderly financial abuse reported in Tennessee every year, and that is only the number that is reported. We are sure that the number is much higher because family members many times will not report other family members, so it's probably about double that. The financial service provider will provide information to the aid in the investigation of a suspected elder financial exploitation. The need for this bill is to help prevent scams of financial exploitation for 65 years and older and other vulnerable adults. It will provide one position for each district attorney's office, which would be 32 in total, to investigate these crimes. It will also create a dedicated office within TBI to create an elder financial reporting system and aid in the investigation of suspected activity. The banks, TBI, the DAs, and all have all worked on this language. Several other agencies have reviewed it and provided input. And with that, Mr. Chairman, I renew my motion.
All right, you've heard an explanation of the bill. Any questions for the sponsor? Question's been called on the bill. We're voting on House Bill 1248. All those in favor say aye. All opposed, no. Ayes have it. Sir, it moves on to finance.
Okay, thank you.
No.
And I have a sign-up sheet if anybody wants.
Yes, it does, finance.
All right, thank you.
Sir.
Thank you, committee.
All right, that brings us to item number 9, House Bill 841 by Chairman Lynn. You have a motion? You have a second? You are recognized.
Thank you, Mr. Chairman. I have an amendment for the bill. It is drafting code 5934.
That's what I'm showing too. You want to hook it on? You want to explain it?
Yes, sir. May we hook it on? And
Hook
then
it
I'll
on.
explain.
All right, we're voting on Amendment 5934. All those in, we need a motion in a second. All right, we got a motion in a second. All those were 5934 is the amendment number. All those in favor say aye. All opposed, no. Ayes have it. The amendment's on the bill. Go ahead.
Thank you, sir. The amendment actually makes the bill. So what it will do is hold book distributors accountable for sending sexually explicit matters to any K through 12 school in Tennessee. Chairman Doggett pointed out to me that sometimes distributors are sending them for free. What I've learned is that librarians say that they will order a gross of books, and when the books arrive, among the craft books and the historical adventure novels and science books will be sexually explicit books, and at that point, the librarians say, well, these now belong to the school system, what do I do? So these distributors certainly know when they pick out these books to send to these K through 12 schools that we have an obscenity law in Tennessee, that they should not be sending these books. If they don't know, our attorney generals can inform them. All we will have to do is have the either state attorney general or district attorney generals inform these distributors you are breaking Title 39, obscenity law, and they can either take them back and give our schools credit, or we can go further and have a deeper conversation with these distributors.
Okay, you've heard an explanation of the bill. I didn't understand you. I'm sorry. Okay, Chairman Gillespie, you're recognized.
Thank you, Mr. Chairman. Representative, I'm just curious. I don't see it here, and I don't mean anything by it, but with obscene, would that also be like a graphic, violent novel as well? Would things like that be captured in this?
Our obscenity law, which is in Title 39:17, the definitions are in 901, and the law itself is 902. So it would be anything that meets the definitions in that law.
Representative Johnson.
Yes, thank you, Mr. Chairman. Again, as I said last time, 27 years in school, not seeing this. In the last week, I've reached out to multiple school systems, multiple schools, principals, teachers, and none of them can give me an example of this ever happening. They're, you know, the books that are sent, they're very careful to make sure that they are age appropriate in reading levels as well as content. And so I feel like we are trying to act as if something that's happening in our school system that is absolutely not.
I'm sorry.
No problem.
It's 5 o'clock, by the way.
Yeah.
Everybody, it's 5 o'clock.
Please tell them that it's a thin crust with extra pepperoni, please.
Got it.
Your phone is recognized.
Thank you, sir. Thank you, sir. This must be a relatively new phenomenon, but what I have heard from librarians is that they're simply coming from packs of books. Now, there are quite a few new schools that have been built in my district in the last few years, but many districts. And of course, librarians, they need to fill up those school libraries. Parents are going to come and look at this new school, and the first or the night before the opening day, and they've got to fill up those libraries. So they order a gross of books for, that age group. It's a middle school, it's a high school, or whatever. Those books come in, and the librarians are telling me these obscene books are in the gross of books that they order. And it must be a new phenomenon. I do not know any deeper than that, but I do know that distributors realize that they are sending these books to a K through 12 school, and what they need to know is that we have an obscenity law in Tennessee, and we take it seriously.
Okay, could you give me the name of a school or one of those librarians so I could verify that?
I certainly will.
Okay, thank you.
Any other question for the sponsor? Representative Fritz.
Thank you, Mr. Chairman. Thank you for bringing this bill. This is an upcoming problem. We have schools in my area that have experienced this, so thank you for the courage to run this bill.
Thank you.
Any other questions for the sponsor? Question been called on the bill, House Bill 841. All those in favor say aye. Aye. All opposed, no. Ayes have it. If you want to register a no with the clerk, feel free. All right, that moves us to item number 10, House Bill 253.
Thank you, Mr. Chairman.
By Representative Parkinson.
Thank you, Mr. Chair. And
One second. Representative Lynn, yours goes to calendar and rules, if I didn't tell you that. Okay. Now, Representative Parkinson, I didn't mean to ignore you right there. You're on House Bill 253. Do I have a motion? In a second? Sir, you are recognized.
thank you, Mr. Chair, and thank you, committee. Mr. Chairman, I didn't feel like I was being ignored, just for the record.
All right.
Truly appreciate you. Lori Delancey, a Nashville businesswoman, enjoyed watching ancestry shows such as Finding Your Roots and Who Do You Think You Are with her husband and stepchildren. As a family, they took home DNA tests, hoping to learn more about their family history, but the test ultimately revealed that her husband's eldest child was not biologically related to him. The deception was a dagger to the entire family unit, as her husband Scott had been a loving provider to the child for over 12 years. Their subsequent paternity fraud case resulted in complete relief from future child support, but it also meant the loss of a child. She was a sister, a niece, and cousin. The emotional loss combined with the financial ramifications was extremely stressful. Plus, there was the constant knowledge that they were deceived for over a decade. Paternity fraud is a real issue nationally. 1/3 of the names listed on birth certificates are not the actual biological fathers. The issue affects parents and children alike. Paternity fraud is a violation of a child's right to know his or her own identity and the identity of his or her father. The child has a right to have a relationship with his or her biological father and mother. Additionally, the proper identification of a child is important for genetic and medical reasons, as well as inheritance and medical insurance coverage. House Bill 253 creates a Class A misdemeanor for anyone who intentionally and knowingly seeks to establish someone as the biological parent of a child when they knew or reasonably knew that the person is not the biological parent of the child. It also creates a Class A misdemeanor for persons who tries to be established as the biological parent, but reasonably knows or should know that they are not the child's biological parent. And with that, Mr. Chairman, I'm open for any questions.
Okay, Representative Hardaway.
Thank you, Chairman. I don't think it's a secret to anybody that I don't believe in criminalizing motherhood. But I'm going to try to get some questions answered. How is it that we determine whether it's intentional or not?
Thank you, Mr. Chair. Do you mind? That'll be left up to the courts and the attorneys to determine if it was intentional or not. Secondly, I do want to respond. We're not criminalizing motherhood, so let's make that in explicitly clear. What we're criminalizing is lying, falsifying, or coercing someone into signing a legal document that would then rob a father of his ability to be a parent to his child. That's what we're criminalizing.
So you've been very specific about rob a father. The standard for dealing with child custody is generally best interest of the child. How does this bill promote that?
Thank you, Mr. Chair. This bill does not stop anyone from adopting a child. This bill simply speaks to someone falsifying or coercing or lying and having another person to listed as the biological parent when that person is not the biological parent.
And maybe I wasn't clear. I'm not talking about adoptions. When I say best interests of the child, I'm talking about custody issues. So how would this bill advance that principle?
Thank you, Mr. Chair. The best interest of the child is to know who he is or who she is. Thank you, Mr. Chair.
And would that best interest also roll over into the child's relationship with the mother?
Mr. Chair, this bill doesn't speak to that. This bill speaks to a mother falsifying or coercing someone into being listed as the biological parent when they're not the actual biological parent.
Well, I appreciate your honesty, because if it doesn't speak to that, then it runs counter, in my opinion, to best interests of the child as determined, probably, I would assume, that the mother would have been determined to be the key to the child being emotionally, psychologically, etc., sound. And I'm wondering, what effect would it have for the child to find out that he or she was at the center of the mother being criminally prosecuted?
Thank you, Mr. Chair. And just so I'm clear, I want to be clear on what it is that you're asking me. Are you asking me, is it in the best interest of the child for his mother to say and falsely list someone else as his biological father when in fact that other person is not his biological father? Is that what you're asking me?
No, sir, I don't know how you get that out of my question. What I'm asking you is, if the best interests of the child is served by putting criminal charges on the mother, and the child be of the notion that he or she is the reason that the mother is charged with the crime.
Thank you. I think I understand you better. The best interest of the child is for the mother to tell the truth from the beginning.
Sir, I'm sure we all agree the best interest of the child would be best served for every adult to tell the truth. But I'm asking what the impact is, in your opinion, on the child if the child knows that the mother is criminally prosecuted and the child is at the center of that prosecution.
Thank you, Mr. Chair. I'll answer it again, maybe in a different way this time. The best interest of the child is for the mother to tell the truth from the beginning.
And I'll assume, since you answered it a different way that wasn't a different way, that you don't have a way to answer it at all.
Mr. Chair, thank you. That would be an erroneous assumption on your part. But again, the best interest of this child is for the mother to tell the truth so that child knows exactly who he is, who his father is biologically without lying, without coercing another individual or getting another individual to say, and lie also possibly, that I'm your biological father when in fact I'm not your biological father. The best interest of that child is to be able to receive the inheritance that he deserves from his biological father. The best interest of that child is to be able to receive a lung if his father, his biological father, is a match. That's the best interest of that child. And if you need me to answer it another way, Representative, I'm happy to answer it another way. But the best interest of that child is not to come into this world off the top with a lie.
Thank you.
You're welcome.
And obviously, you don't have a different way of answering.
I don't have to have a different way of answering. You asked me the same question 5 times, and I've answered it for you.
All right, we're moving down the wrong road almost here. You have another question, Representative Hardaway?
I have plenty of them, Chairman. Thank you. Does the legislation include any mental health care for the child whose daddy just walked out or was put out of his or her life?
Go ahead. Mr. Chair, that has absolutely nothing to do with the bill.
Do you think it's important that there be mental health care available to the child to address the trauma of losing a father?
Go ahead.
Mr. Chair, with this bill, the child is actually gaining his father. But I don't understand what this question has to do with the bill. We're simply saying that we don't want parental fraud. It has nothing to do with insurance or mental health coverage or anything like that. It only has to deal with parental fraud, Mr. Chair.
All right, and I've run parental fraud, paternity fraud before. It was not about criminal charges. It was about the father being able to recoup the financial impact. So I'm wondering, why do you think, and I'm not aware that this is not working, so why are we putting it in the criminal rank? Why are we criminalizing motherhood?
Thank you, Mr. Chair.
Yes, sir.
Thank you, sir. You know, most of the questions that you're asking, Representative, have nothing to do with the bill. And my suggestion would be that you bring a bill. If you want to see something different, then bring a bill, and you know we'll vote it up or down. But this line of question has nothing. Mental health, and I renew my motion.
Sir, you can't renew your motion in the middle of the time that I have on the floor. This is my time. I only have a couple of more questions, if you can kind of steel yourself for. So, let's get back to the mother and how the proof is determined, either in the beginning or in the end. Is it going to be DNA tests that are done?
Go ahead.
There could very well be.
Is there another way that's more certain?
I'm not sure how you become more certain than DNA test.
So your level of proof would be DNA?
I don't have any level of proof. I'm not in the situation. DNA can be used to determine the biological parent.
All right, should the father, should the mother not get that DNA test in the beginning?
Has nothing to do with the bill.
Sir, I would beg to differ. If that test is done, then the bill is unnecessary. Would you agree?
If they choose to get a test, they're more than welcome to, but this does not have anything to do with them getting a DNA test. This just simply tells them parental fraud is illegal.
So you have no idea on how to prevent parental fraud, merely how to punish it?
Thank you, Mr. Chair. It doesn't matter if I have any ideas how to prevent it, how to punish it, or whatever. This bill simply says it's illegal to commit parental fraud.
Well, sir,
my experience And parental fraud has absolutely nothing to do with this bill. It just simply says it's illegal to commit parental fraud.
Well, sir, hearing that you don't have any ideas, I'm going to relinquish the floor. Thank you, Mr. Chairman. I'm voting against your bill.
Representative
I think
Davis.
it's a sin and a shame that we're criminalizing motherhood.
Representative Davis, you're recognized.
Thank you, Mr. Chair. And so I just wanted to clarify that last week in subcommittee, you had an amendment because the Senate had changed the classification to B, and you, in their original bill, it's A. So we're staying with A. Is that correct? I just want to make sure that we're still on that same track.
Yes, sir.
Thank you, Mr. Chair, and thank you, Representative. I had changed I had amended this bill to a Class B and sent it to the Senate because I thought I was going to keep it as a Class B. The members of the subcommittee thought it should be a Class A. So we didn't put the Class B amendment on there. So the Senate is going to follow whatever we decide to do on it. Yes, ma'am. Thank you.
Vice Chair Gillespie. Question been called. We're now voting on House Bill 253. All those in favor say aye. All opposed, no. The ayes have it. It moves on to calendar and rules, Representative.
Thank you, Mr. Chair. Thank you, Representative Hardaway.
All right, we are now moving up to House Bill 24 by Representative Freeman. You got a motion? You got a second? You're recognized, sir.
Thank you, Committee and Chair. I believe I've got an amendment.
Let me make sure I got the right amendment.
4918.
4918. That's what I'm showing. You want to explain it or do you want to attach it?
Let's attach it. It makes the bill.
All right, I did hear a motion and a second. We're voting on Amendment 4918. All those in favor say aye. All opposed, no. Ayes have it. 4918's on your bill.
Thank you, Chairman. So there's another bill that is currently working its way through the House that would require the TBI to test rape kits within 60 days. This is a backup to that. If they end up not getting through calendar and rules with that bill, this would require the TBI to submit back to us what the cost and the real cost would be to implement this 60-day testing requirement. And with that, I stand ready to answer any questions.
Any questions for the sponsor? Okay, we're voting on House Bill 24 as amended. All those in favor say aye. All opposed, no. Ayes have it. Sir, that bill moves on to calendar and rules.
Thank you, Committee and Chair.
You're now recognized on item number 12, House Bill 686.
Thank you, sir.
Do I have a motion? Oh, you got a motion and a second. Go ahead, sir.
I also have an amendment here as well, drafting code 5093.
That's what I have. You want to attach it or explain it?
We can attach it. It makes the bill.
All right. I need a motion and a second. On Amendment 5093, all those in favor say aye. All opposed, no. Ayes have it. 5093 is on the bill. You're recognized.
Thank you, sir. I have a witness to speak. Would you like for me to describe the bill a little bit and then let them come up, or do you want, which order?
It's your bill. You play it any way you want.
Okay, sir. Well, I'm going to do a little bit of describing, and then we'll have them up if anybody would like to ask questions. So, House Bill 686, sorry, I can't read, is my advocate confidentiality bill. There are 37 other states that have passed this. It's passed the Senate 3 times in a row. It actually just passed it again just not 2 minutes ago. This bill would prohibit advocates from being examined in any judicial, legislative, or administrative proceedings regarding any communication between the advocate and the victim unless disclosure is required by law or otherwise authorized in the bill. The privilege belongs to the victim and only be waived by the victim in writing. A few exceptions apply, including advocates must still disclose child and elder abuse, and a court has discretion for in-camera review of communications upon petition by a party. With that, I stand ready to answer any questions.
Are there any questions for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman. I saw some note about whether DCS is excluded. So what's the final version? DCS would have access, or DCS would go through the courts to get access, or
So,
is it something you want me to pose to legal?
yes, if you don't mind.
Mr. Chairman, if you would.
We'll go out of session for legal.
Michelle Fogarty, Legal Services. The amendment defines victim services provider as an entity or organization providing direct services to victims, but does not include a law enforcement agency, the Department of Children's Services, the Department of Human Services, the Division of Adult Protective Services, or the Office of a District Attorney General.
All right, any questions for the
That does
legal?
it for me. Thank you. Thank you, sponsor.
Any other questions for legal? All right, we're back in session. Continue, sir. Any other question for the
We need my
sponsor?
motion.
Question been called on the bill. We're voting on House bills.
Would we like for someone to testify? Or
Oh, well, I don't know. You've already sold the bill. Why you need it?
Okay. All right. I renew my motion.
All right, I was hoping for that. We're voting on House Bill 686. All those in favor say aye. All opposed, no. Ayes have it, sir. You move on to calendar and rules.
Thank you, committee and chair. Fourth time's a charm.
We're now on House Bill, or item number 13, House Bill 415 by Representative Davis. You have a motion. You have a second. Representative, you're recognized.
Chairman, would you like for me to, can I present here, or would you like for me to go
You're
to the podium?
fine right where you're
Okay.
at, and I'm showing an amendment.
Yes, sir. So I do. I have Amendment 6146. It makes the bill and also changes the fiscal note to not significant.
Okay, that's the amendment you want, 6416. All right, that's what we're voting on. All those in favor say aye. Wait a second. You can vote. We didn't get a motion in a second. We did? Well, I didn't hear it. You're going to be a little more verbal here now. Second. So you hear that second? That's the way we need the motion. It's just like that. All right. We've got a motion to second. We're voting on Amendment 6416. All those in favor say aye. All opposed, no. Ayes have it. Amendments on the bill. You may proceed. Thank you.
Thank you, Mr. Chairman, and thank you, committee. And so essentially what this bill does is it creates a sexual assault team, and it's a collaborative team of folks that have expertise in this knowledge. What we did change with regard to the amendment, it was we removed some of the people with regard to the team members, but we wanted to ensure that we had people with expert knowledge that might be able to come together and collaborate and ensure that any redundancies in policies, that we're talking about those things, or if we see any sort of uptick in any sort of cases, that we have the ability to collaborate and come to best practices. And so that's what this task force does. So I renew my motion.
All right. Any questions for the sponsor? Representative Fritz.
Thank you, Mr. Chairman. I appreciate the bill. I'm fully in support of it. It refers to law enforcement agencies. So in the small rural counties where the availability of resources are fewer, will this bill allow a sheriff's department to perform that function for smaller cities or cases like that?
Go ahead.
Yes, sir. And essentially, it's we would love for them to be able to participate, but if there's not someone that's available, they can. One of the things that we did do with this new amendment to include it is that they can always telephone in or Zoom in, so that way that'll help provide some of that if they're not able to be physically present. But at least we wanted to ensure that they had the information to be included in that process.
Okay. Any other questions for the sponsor? All right, we are voting on House Bill 415. All those in favor say aye. All opposed, no. Ayes have it. It moves on to calendar and rules. That brings us to the enhancement calendar, I believe. All right, on the enhancement calendar, item 1, which is House Bill 3, we're going to roll to the first calendar of 2000. Oh, gotcha. My bad. We're going to roll it to the enhancement calendar of 2024. I don't think I have to take a motion, or do I have to vote on that? Without objection. I feel good about it. All right, we're so moved and so done. All right. By the time I get to some more of them words like collaborate and love and all them fuzzy words that Representative Davis had, I'm just really feeling good about this. All right. We are on item number 2, House Bill 1013 by Chairman Grills. Where did he go? All right. We'll move to the Hill. We're on now item number 3, House Bill 248. That's off notice. No, I'm sorry. We have rolled to next week. All right, I'm trying to read my notes here. Bear with me, we're almost through. Item number 4 is House Bill 986, which is off notice. We're now on item number 5, House Bill 1081 by Representative Parkinson.
Thank you, Mr. Chair.
I need a motion. I need a second. You got a motion and a second. You recognize, sir.
Thank you, Mr. Chair, and thank you, Representative, for that motion, and thank you, Representative, for that second. Truly appreciate you. Tyree Nichols was a father of a 4-year-old son. He was known to his family as an avid skateboarder and nature photographer. He lived in Memphis he moved to Memphis, just before the pandemic and started a job with FedEx. He had been with the company for about 9 months when he was pulled over on January 7th for what police said was reckless driving. Tyree Nichols was unarmed. He was aggressively beaten by police officers, and 3 days later, he died in the hospital. It pained us all to watch the video of Tyree Nichols' death at the hands of bad actors in law enforcement. And we owe it to the parents of Tyree, Mr. and Mrs. Wells, their families and friends, but also to the citizens of the state of Tennessee. It is our job as leaders in the state of Tennessee to put forth policies that would deter such actions and to protect them. And Mr. Chair, before I say what this bill does, I want everyone on the committee to know that all of our Tennessee law enforcement agencies came together to bring the language of this bill. So they're all in agreement. They're all in support of this bill. As a matter of fact, the language was brought by our Tennessee law enforcement agencies. And what this bill does, it creates an enhancement just like that civilians receive when they assault a police officer. That's those same enhancements for robberies, homicides, kidnapping, false imprisonment, and sexual offenses are applied or can be applied by the judge when an officer does it to a civilian. This bill allows the court to order an enhanced sentence if the offense was committed by a law enforcement officer during the performance of official duties. And with that, Mr. Chair, I'm open for any questions.
All right, questions for the sponsor. We have an amendment here. I'm showing 5510. Is that what you have?
Yes, sir.
Okay, you got a motion to second. We're voting on Amendment 5510. All those in favor say aye. All opposed, no. The amendment's on the bill. Any question for the sponsor? Representative Hardaway.
Thank you, Chairman.
Do you not get along with him?
Thank you, Mr. Chairman.
Joe Towns? Mr. Chairman, I get along with anyone that brings good bills, but I'm not going to criminalize motherhood. The bill that's before us now is a good bill. The situation that happened with Tyree Nichols is not just regrettable, it's just horrible, it's reprehensible when those in authority choose to use that authority to follow unlawful policing methods, and it ought to be criminalized to the utmost. And I think anything that will deter the violation of constitutional rights by those who are charged with protecting constitutional rights is a good thing. Thank you, Mr. Chairman.
Any other question for the sponsor? Can you withdraw for just 1 second so I make one comment? Thank you. Representative, there is no justification for what happened in Memphis at all. As is quoted, it's reprehensible, it's wrong, straight up wrong. I've always been against enhancing penalties because you set people on different planes, you make one person more important than another person, and I've always been against that, and I'm against it for the very same reason here. I just want you to know that. I appreciate what you're trying to do, and people do hold police to a higher standard. They do. But I want police to have the same level playing field and justice to be equal, just like anybody else. So I oppose your bill, but I certainly understand where you're coming from. So, yes, sir.
Thank you, Mr. Chair. And I think it's important to note also that when I sat down with law enforcement, you know, my first idea was to look at the immunity portion of it. And, you know, and tied to, I think myself and Chairman Farmer, we talked about this, tied to the body cams. And I'm glad that I sat down with them, because one thing that was pointed out to me was that if we went that direction, you know, a lot of these departments would probably start taking their body cams off. And we don't want that. And the one thing that was pointed out with all agencies that, you know, because we all sat down together, was that they want the bad actors out too, because it's affecting them, and it's affecting recruitment, it's affecting good policing, and other things that they have to deal with as law enforcement agencies. And so, you know, I'm thankful to them that they actually came up with this language to level the playing field for, and the good thing, the beauty about this legislation is this: it only speaks to the bad actors, not the good people, not the good officers, which is the majority of our officers that are wearing that uniform. And so that's what's good about this legislation. I understand your position on enhancements, but this legislation, it goes directly to those bad actors that are affecting everything that we do, whether it's inside the police department or inside our communities. And thanks again, Mr. Chair.
All right, Representative Towns, you want to call the question?
We call the question, Mr. Chairman. Thank you.
Question's been called. We're voting on House Bill 1081. All those in favor say aye. Aye. All opposed, no. No. Ayes have it. Thank you, Representative.
Thank you, Mr. Chair. Where am I going?
You're going to calendar and rules.
Thank you, Mr. Chair. Appreciate it. Thank you, committee.
And now we're back on item 2. I'm sorry, 2. Yes, item 2. Crying out loud. Chairman Grills? Yes, sir. I am glad Sergeant at Arms was successful in retrieving you. We're on House Bill 1013. Is there a motion? And a second? You have a motion and a second, sir. You're recognized.
Thank you, Mr. Chairman, and thank you, Mr. Tyler, for coming and getting me. I appreciate that. As introduced, this clarifies that a sheriff and a sheriff's deputy are law enforcement officers for the purpose of the criminal code, and clarifies that a deputy jailer is a law enforcement officer only for the purpose of the enhancement of a crime under the criminal code. I renew my motion.
All right, you heard an explanation of the bill. Are there any questions for the sponsor? Yes, Leader.
Mr. Chairman, at some point, I'm going to get a ruling from the clerk. It's happened about 12 times today, but I don't think you can renew your motion here unless you're a member of the committee. So I'm not picking on this representative, but it's happened several times. In fact, a representative earlier tried to get himself out of some tough questioning by just renewing motions. But on the floor, you can do that. But I didn't bring it up. So.
All right, Representative or Chairman, in the future, would you like me to renew your motion for you?
I would oblige you.
All right. Are there any questions for the sponsor of the bill? He renews his motion. I, sir, am against your bill for the same reason I've stated. All right, we're voting on House Bill 1013. All those in favor say aye. Aye. All opposed, no. That'd be me. The ayes have it, sir. You move to calendar and rules.
Thank you, Chairman and committee. Y'all have a good afternoon.
Yes, Leader.
Mr. Chairman, the good Lord himself renewed a motion in Paul Sherrill today. It's his birthday, so he gave him another year on this earth. So
Well, happy
I want to
birthday.
say happy birthday.
All right, is there any other business? We have a motion to adjourn. So moved.